Well, as everyone is aware, this is the first sitting of the Caribbean Court of Justice. It is therefore a historic occasion, and it is a pity that it has to be held in such cramped conditions. This is not going to be the permanent or even semi-permanent home of the court. The court is to be housed initially, as is generally known now, in a building in Henry Street, Upper Henry Street, which is being prepared for use by the court. Unfortunately, the work in that building is not yet complete. I will not be rash enough to predict when it will be ready. The work is, of course, being undertaken at the instance and the expense of the Trinidad and Tobago government. But the time within which it will be ready, all I can say is to be counted in months. I am sorry that we have to suffer the inconvenience of sitting in these very confined conditions, but we make the best of it. So far as our future sittings of the court are concerned, we will have to consider our options with regard to venue. But we certainly did not think that the work of the court should be delayed in any way by the fact that we don't have available to us the most appropriate accommodation. So I ask you to bear with these conditions, as we will be doing. We are particularly concerned about the limitations on the available space for the media, but we have tried to arrange it so that despite the few number of seats available to them, there will be an element of pooling which will enable the proceedings of the court to be transmitted in one form or another to as wide a public in the region as possible. Well, we now proceed to the business of the day. Would you call the matter?
Caribbean Court of Justice, number AL 0001 of 2005, between Barbados Rediffusion Service Limited versus Asha Mirchandani, Ram Mirchandani, and McDonald Farms Limited.
I appear on behalf of the applicant, and with me associated Mr. Al Bullock and Mr. C. Ordain. I should say that my name is Henry Ford.
Your Honors, I appear on behalf of the respondents, and with me are Mr. David Thompson, Ms. Monica Stewart, and Ms. Shalika Jordan. My name is Clement here, Lashley.
Yes, thank you. Yes, Sir Henry.
Your Honors, before we begin the formal submissions, I crave Your Honor's leave to just make probably a very limited remark to say that it is indeed a very historic occasion. Historic not only for Barbados, who comes as the first country to have its litigants before this court, but historical as well for the Caribbean as a whole. Your Honor, Mr. President, has been in the forefront of the fight for a Caribbean Court of Justice for the whole of your career. I had the privilege myself to be associated with many more distinguished jurists who preceded us, whose idea it was. We're therefore happy today that it is a culmination of that idea. And this small step in this small building It's a small step, of course, for the Caribbean in some ways, but it is a large step for the establishment of Caribbean justice in its own setting. I'm indeed happy that this court has a tradition already that will be upheld, and in particular, I'm indeed privileged to be one of the surviving lawyers who was able to appear before the federal court. And I have no doubt that that court, which established itself in the Caribbean as an outstanding one, will be the precursor of the higher things that your lordships will accomplish. So on behalf of my colleagues, we are delighted to be here and to be able to address you.
Thank you, Sir Henry.
Your Honours, I wish to endorse the remarks of my very friend Sir Henry Ford, and I wish to congratulate Your Honours of forming history being appointed the first judges to this court. And we do look forward to the provision of jurisprudence in this court to the future. As your Lordship, as well.
Thank you, Mr. Lashley. Yes, Henry. Would you like to speak at the podium?
Your Honours, before I begin the submissions, there are a few housekeeping matters. We had asked for an amendment to paragraph 3 of the notice of application.
Yes, I understand there is no objection from Mr. Lashley.
That is correct.
Thank you.
We grant the amendment.
Thank
we
you, sir.
had notice of it.
Yes. Your Honours, we've also handed in our written submissions and have exchanged them today.
But Sir Henry, may I say that it was unfortunate that we only received them here on Saturday evening.
Yes, Your Honour. I think it's very unfortunate, but this has been a pretty tough time schedule for us in order to be here. We've also exchanged them with the other side and have received a copy of their documents.
Yes.
Your Honour, this application really arises under Rule 10.4 of the Caribbean Court of Justice Appellate Rules 205, and it's an application for special leave to appeal from the Court of Appeal of Barbados made on the 20th of August 2004, which I will refer to as the substantive judgment of the Court of Appeal, and a decision of the Court of Appeal given on the 23rd of June 2005, which I will refer to as the decision on leave. The application was filed on the 14th of July and sets out briefly the background facts. And in my opening, I may refer to some additional facts that dates, in fact, based on the chronology and the statement of events. Well, the basic background facts is that in September 1990, the respondents issued a summons claiming against the applicant general damages for libel and special damages quantified in their particulars of claim in roughly 2.8 million Barbados dollars. The applicant is a company which is in the business of broadcasting and licensed under the laws of Barbados to broadcast radio programs by wireless. The first respondent is the wife of the second respondent, and they are directors of the third respondent. The third respondent is a company still, which formerly carried on the business of slaughtering and processing chickens for wholesale and retail distribution, and as such, the business had to obtain a license under the Public Health regulations, and it was inspected from time to time by the public health officials. Like most of the countries of the Caribbean, Barbados celebrates Carnival and a festival known as the Crop Over Festival. And it's organized by the National Cultural Foundation, a statutory body. And in 1989, the applicant broadcast on its radio station, Voice of Barbados, 3 calypsos, the Mad Chicken Song, Pluck It, and Tit for Tat, in which the singers made references to a chicken farm where it was alleged chickens were processed for public consumption in unsanitary conditions. The applicant did not admit in the proceedings that were filed the publications, but pleaded in an alternative that the publications did not refer to the plaintiffs and further the defense of justification. Earlier, the applicant had pleaded qualified privilege under a moral, legal, and social responsibility, but this was struck out, and there's no appeal pending on that at the time. The application for directions came on the 7th of July 1992 before Mr. Justice Husbands, and he ordered the parties to exchange documents within 42 days and to file the usual affidavit verifying the list. The respondents filed their list on the 15th of September, a year and a month after the time allowed under the rules, and the next day took out a summons to strike out the applicant's defense because of its failure to file its list of documents. The applicant filed its list on the 23rd of November, and thereafter the respondents took no further steps in the proceedings until the 12th of October 1994, when, without leave and without filing a certificate of urgency, they took out a summons returnable on the next day, the 13th of October 1994, applying for an affidavit verifying the list and a further and better list. An affidavit verifying the applicant's list had been filed ever since November 1993. This summons was disposed of on the 24th of November 1994, and the application of the respondents did not state under which rule it was brought, but purported to be for a general discovery. It was made and heard at a time when the applicant's then counsel had recently assumed the office of Attorney General and was in the process of making arrangements for handing over his papers to other counsel. The order was made with the defendant absent. On the 20th of February 1995, the then Chief Justice Sir Denise Williams made an unless order in the terms set out under paragraph 2.7 of the skeleton arguments, and which is a copy of the order is referred to in the affidavit sworn by my learned friend, Mr. Clement Lashley. In response to the said summons, Mr. Fernandes, the managing director of the applicant, filed an affidavit on the 28th of November 1995, and within that affidavit, although he took objections to the further orders being made and reserved his position, he deposed to having made a search of the station's library, archives, and premises, and was being unable to find any tape of record of any broadcast of the semi-finals or finals of the Pick of the Crop competition of the 8th of July and the 4th of August 1989.
Was a further list in an affidavit filed after the making of the unless order?
There was a further list filed after the making of the unless order, which contained three additional documents, which were described as merely formal documents. There were no other documents filed than those.
But the affidavit of Mr. Fernandes wasn't filed until a good deal later then?
No, that affidavit was filed after an application was made by the respondents that there was non-compliance with the order. And in response to that, That affidavit, however, made the point that the applicant further former affidavits were conclusive, and that there should be no further affidavit in the absence of an application under Order 24 Rule 7, as distinct from Order 24 Rule 3, because there was nothing in the affidavits as sworn which showed that there were additional documents. And that argument is developed a bit further. My lad, we do have a copy of the affidavit. It hasn't been made available, but if necessary, I would refer to it to clarify the position of the court.
One problem I have, Henry, is that part of your argument is that the unless order was really wrongly made.
Yes, my lord.
But there was no appeal of it. And the striking out of the defense was as a result of disobedience, of that alleged disobedience, of that order, which is a challenge. And I have a concern now.
My lord, there has been an appeal against the unless order. There was an appeal.
There was?
An appeal against the unless order.
What happened to it?
There was an appeal from the judgment of Mr. Justice Husbands striking out.
No, but that wasn't there. He didn't make the unless order.
No, my lord. There was no appeal as such on the unless order. What happened is that further documents were filed. Not this affidavit of finance.
My problem is,
yes,
how can you justify disobedience of an order by complaining that the order ought not to have been made when that order was never appealed from?
My lord, we're not. What we're saying is that there was a compliance with the order as far as the applicant is concerned, because we did file a further and better list. What Mr. Justice Husbands had to determine was whether that further and better list was compliance. So that,
yes.
And he determined that there was no compliance and that there was contumely and intentional non-compliance. And that is the issue before this court.
Well, it just seems to me that you might be on a better wicket in contending that there was compliance, since Mr. Fernandez's affidavit demonstrates that there was no other document to disclose.
Yes.
Rather than attacking the correctness of the unless order.
My lord,
it just strikes me.
Yes, my lord. What we are attacking at that stage was the finding or the conclusion of the learned trial judge that there was non-compliance.
Right.
And what we were arguing is that he was not in a position in those circumstances to make the order striking out.
Yes. All right. Thank you.
What he heard then, because the respondents filed an application before him to strike out, alleging non-compliance. And that was the application which was heard over the period of 8 days. And I'm looking at the argument at the outline skeleton arguments at 211. 2.11. In 1996, Husbands over the course of 8 days heard argument as to the application of Order 23 or Order 27, Order 24 Rule 3 or Order 24 Rule 7 to the circumstances of the case, where he characterized the issue as the respondents allege that the applicant had specific documents, namely tape recordings of a broadcast, and was refusing to disclose them. The applicant, on the other hand, swore that its list of documents disclosed all documents in its custody, possession, and power, and it had no tape recordings of the calypsos or logger tapes. After 8 days of hearing, the matter concluded on September the 19th, 1996. And the decision was given more than 3 years later on the 24th of November, 1999. When husband struck out the applicant's defense, the applicant appealed the decision of husbands by notice of appeal dated the 7th of December, 1999. And it took over 4 years, namely from the 17th of July 2000 to the 20th of August 2000, for the Court of Appeal to give its decision, which is one of the decisions complained of in this application for special leave. But that is, this is the first occasion on which an application is being made for special leave to this court from a decision of the Barbados Court of Appeal. It is, in my humble submission, appropriate to state the basis and principles on which the court is being asked to exercise its jurisdiction. The Caribbean Court of Justice Act 203 was proclaimed on the 8th of April 2005. It was amended by the Caribbean Court of Justice Amendment Act 205, and that act was proclaimed on the 14th of April 205. The Barbados Constitution Amendment Acts numbers 2003 numbers 9 and 10 were proclaimed on the 8th of April 2005. And the combined effect of these acts, in my submission, was to establish this court as the final court of appeal for Barbados and to abolish appeals to the Privy Council, except in the limited circumstances provided in Section 25 of the Caribbean Court of Justice Act 2003, number 9. It is submitted, therefore, that this court has jurisdiction by virtue of Sections 4(1)(b), Sections 7 and 8 of the Caribbean Court of Justice Act to grant special leave to the applicant to appeal from the decisions of the Court of Appeal the applicant's application for leave to appeal to the Privy Council had been filed on the 10th of September 2004, heard by the Court of Appeal on the 7th and 8th March 2005, and a decision handed down on the 23rd of April 2005. Of June, 2005, my lord. It is submitted that on that date there was no pending appeal before the Privy Council, as is provided for in Sections 25(1) and 2 of the Caribbean Court of Justice Act. But that if it becomes necessary, I'll read the provisions, but I'm sure your lordships are fully au fait with those provisions.
I am interested in the question of jurisdiction.
Thank you, Miller.
If we can go back, first of all, to the sections you mentioned, which provide for this court to give special leave. Sections
1B.
7 and 8. Do they contain any guidance as to what considerations should govern the grant of special leave?
They do, my lord. Section 7 contains a guidance which
Would you read it for us?
an appeal shall lie to the court with the leave of the Court of Appeal from decisions of the Court of Appeal in any civil proceedings where, in the opinion of the Court of Appeal...
Yes, but that is for applications
to the Court of Appeal.
Yes,
Yes,
I'm talking about on applications
Yes.
to this court. for
To this
special
court
leave.
would be Section 7. Section 8, which says, subject to Section 7, an appeal shall lie to the court with a special leave of the court from any decision of the Court of Appeal from any civil or criminal matter.
But that doesn't give the guidance which I am inquiring about.
It doesn't provide the guidance in the terms that are provided in Section 7
Well,
to the Court of Appeal itself.
you know, this system replicates what existed previously with the substitution of the Caribbean Court of Justice for the Judicial Committee. And if one of the questions which I think we have to decide is whether we are going to adopt the same approach and the same principles towards the grant of special leave has guided the Judicial Committee.
But the whole concept of special leave as developed by the Judicial Committee was really over a long period of time and based on the circumstances that existed. There are cases coming from the court, the Judicial Committee, which limited appeals from some countries in the way that they had granted, on the same principles that they had granted leave, special leave to appeal in another dominion at the time. So there has been a development of the law in that respect. I would expect that this court would wish to set out its own principles within, of course, the special circumstances of acknowledging as well the history of the development of the law that has taken place within the Privy Council and that will continue to take place, particularly as the Privy Council in some of its judgments has clearly pointed out that the categories are not closed.
Mr. Ford, could you comment on the subject to Section 7 in Section 8?
Yes.
Does it mean that Section 7 provides for appeals with leave of the Court of Appeal? Section 8 applies to special leave to be obtained. But the word subject to Section 7, does it necessarily mean that you have to exhaust your appeals first before the Court of Appeal, before you can come to special leave?
I have not interpreted it, Your Honor, in that way. The word subject to Section 7 means that either you must exhaust, or alternatively, that the conditions laid out in 7A1 are conditions that the Court of Appeal, the Caribbean Court of this court must take into account in dealing with special leave.
But it seems odd that it's subject to Section 7. That is what is exercising that.
The word subject to Section 7 prima facie seems to me to say once you've exhausted your leave, you can then come to this court.
But that's one interpretation.
That's one interpretation.
So Henry, is another possible one that it means subject to the application of Section 7, where Section 7 is applicable. And in these particular transitional proceedings, there was no scope for Section 7 to apply, because before April you couldn't apply for special leave to the Barbados court to come to us because we weren't around then.
No, my lad. You couldn't before the court was established to apply for leave.
Right.
But one has to read those sections as well against the provision of Section 25. And Section 25 provides that the provisions of Section 4.1 shall not affect any proceedings before the Judicial Committee of the Privy Council immediately before the commencement of the Act. But it defines under Section 2 what proceedings shall be treated as pending. And it is only those proceedings where leave to appeal to the Privy Council have been granted that have pending proceedings.
That's right. It's clear that there's no possibility of any appeal to the Privy Council now.
That's right.
And I also believe that this court itself has exclusive jurisdiction to determine whether it has jurisdiction in this matter.
That's right.
But that may be a point you want to develop later. But this is a rather special case, isn't it? In that you can't go to the Privy Council. It may be that an argument is going to be put that that's an end of the matter, and you fall into a hole in the legislation. And my question is whether one can block the hole in the legislation by saying that the subject to Section 7 means subject to the application of Section 7. And in your particular case, there's no scope for Section 7 to apply, because you could never have applied to get special leave to come to this court before April. You had to go the Privy Council route.
Yes,
that failed. But the question then is whether you can have recourse to Section 8. And then, as the President has pointed out, on what basis do we apply Section 8? Do we look back at the need for there to be great general or public importance or otherwise, when, of course, in the Barbados Court of Appeal, when going to the Privy Council, the Barbados Court of Appeal only had to consider whether there was general or public importance. We seem to have raised the stakes with the extra word great inserted under the agreement to set up the CCJ.
Well, if I may deal with the word great, the word great is no different from the word grave in my humble submission. And the word grave is no different in my humble submission from the word important and the normal Oxford Dictionary. So that
I know that you were urging us not to feel confined, to follow the or constrained, to adopt the approach of the Privy Council to the granting of special leave. But my understanding of their practice is that they did not confine themselves to the test which the Court of Appeal was required to apply of general public importance or great public importance. But they felt that they had a wider discretion which could be invoked if there was a substantial miscarriage of justice that might have occurred.
Yes, my lad, and that is repeated in several of their cases, even in the classic cases on which the other side rely in the court below, and I have no doubt are relying in this court above. And that is why I said that the jurisdiction and the principles were still developing, and I have no doubt would have developed further for Barbados and those countries that are no longer going to the Judicial Committee, had we remained in, and particularly given two significant developments. And the significant developments is that all of our constitutions, including the Constitution of Barbados, emphasizes, almost in the terms of the European Convention on Human Rights, the need to have access to the court, and that the UK's jurisdiction on human rights have been expanded now by the Human Rights Act. And one has seen, if you look at the trend in interpreting these type of situations, almost a change from the technical to what I would say is the term to the development of the more substantive rights of people to have a fair trial. If we were being confined by saying that there was no right at all to appeal after the Court of Appeal was heard, it would mean that you may have two sets of cases and two sets of circumstances, and that if the court, if a case is still outstanding after the commencement of the acts of the various legislation and no decision has been given, until after the coming into being of the Act. If this section is interpreted in a limited way, then in those circumstances the person would have been denied the opportunity that they had under existing legislation to have gone to the Privy Council and to come to a final court in order to make that determination. And if this is so, it would apply not only in civil cases, but what would even be more trying would be in criminal cases where the freedom of the subject may be more seriously involved.
But may I point out that there seems to be a discrepancy between the transitional provisions in the CCJ Act and those in the Constitution Amendment Act. In that, in the Constitution Amendment Act, there are specifically accepted from the application of the new system cases in which there is an application pending to the Judicial Committee. That is, would cover a case where there was an application for special leave pending, whereas in the case of the CCJ Act, that act only accepts those cases in which leave was actually granted at the time when the amendment took effect. Is that not so?
But I haven't interpreted the sections with that in that narrow way.
Well, it's not a narrow way. That's what it says, surely. I think your quarrel should be with the draftsman.
But that I have interpreted it.
But do you see what I mean?
I'm seeing what your lordship means, yes. But
I mean, can you interpret it any other way?
But that I've interpreted it as not depriving a person of a right to go, even if the case is not pending.
Sir Henry, assuming that we accept your interpretation of the subject to Section 7, and that you could come to this court for special leave, it means that you're coming under Rule 10.4 for leave to appeal within 42 days of the date of the judgment. Or, they're separate, in cases where leave is refused within 21 days. Let us assume, don't you think you were going to be in a bit of trouble there with the 42 days from the date of judgment? The judgment was delivered in July 2004.
Your Honor, with respect, I humbly submit not, because we have an alternative, or in cases in which leave to appeal is refused. Unless one interpreted to say in which case, or in cases in which leave to appeal to this court is refused by the Court of Appeal.
That's what I was thinking.
And that is substituting words.
I think that the respondents will say, or they perhaps are saying, that the phrase in which leave to appeal is refused relates specifically to leave to appeal to this court as distinct from leave to appeal to another court, i.e. the Privy Council.
But one must accept that as before the change in the court system, the litigant had the right to appeal
To the Privy Council.
to the Privy Council. But it was a right to appeal to a final court. It is my submission that there have to be clearer words than that in order to abrogate that right to appeal to a final court. And that the right to appeal to a final court, either as of right or through the Court of Appeal or through the Privy Council can be accommodated within the specific provisions of either Section 25 or within the provisions of Sections 4 and 8
If
of
not, you
the
will
Act.
fall into a hole. It means that
Otherwise,
the matter is not pending. There is no pending appeal to the Privy Council because of the legislation. And you have nowhere to go because the leave was to the Privy Council, that was refused. But they had refused leave to go to the Privy Council.
May I-
There is no longer Privy Council. Therefore, you're asking us to say that then that means leave to appeal to whatever court that succeeded
Yes.
the Privy Council.
yes, because even if leave to appeal was granted, then in my submission, we would have had to come to this court.
Really?
That's my argument.
So that if you had got leave to appeal to the Privy Council, you couldn't have used it.
Because under Section 25, I'm saying that at that time there was no pending appeal. And the manner in which the pending appeal is determined is defined under Section 25(2).
Yes, but irrespective of the specific exclusions contained in those sections, is there not a general principle which would operate against giving an act retrospective effect so as to deprive the person of a vested right of appeal?
And that's exactly why I said it was a restrictive interpretation. If one took it to be abrogating rights that existed, and that's why I'm urging the court to see it as a right to appeal or to ask for leave to appeal to a final court rather than necessarily a named court for this purpose. One has to accept that our final courts have changed. One has to accept that we have preserved the special leave provision which allows a litigant to come to a final court. And therefore, if one isolates this exceptional circumstances, unusual circumstances, that a judgment is delayed or comes at a certain time, where the application had been made earlier with the expectation that you would have had that application disposed of so that you could fall within the rubric of existing law. Now, it's no fault of any litigant that the application was not disposed of until a change in the legislation.
But you mean that if you had got your leave on the when was the judgment given?
The 23rd of June.
23rd of June. That you could have used that leave to come to us, or you would have had to apply for special leave to us.
Well, that I have submitted that we could use that leave to come to this court. And that would have been my interpretation of it, given the principle of not abrogating the rights, and because there's a final court here. I was taking the Section 25(2) is in a way a narrow section, because it defines what is pending before the court, the Privy Council.
The leave would have had to have been granted before April, before the commencement.
Before the commencement.
And in June it would have
That's right.
been too late.
Yes.
So that leave, if you had gotten leave, it would either have been superfluous or you would have been able in your submission to use that leave to come to this court.
Yes, my lord.
Well, that it might have been superfluous is another argument that could be made.
It would have been superfluous, but I'm saying we could have used that leave in order to bring our appeal before the court, this court.
Would have been a brutum fulmen.
Yes, my lord.
But with regard to the question of the time limit, I thought that you might have referred to Rule 19, which seems to me might be of assistance.
Your Lordship is dealing with a transitional rule.
Yes.
That provides that in case of appeals from judgments delivered before the coming into force of these rules, the time for doing any act shall not begin to run until the day after that on which these rules came into force. So that's why, in answer to Your Honor, I interpret it as saying that we had the alternative time of 21 days rather than the 42 days.
Well, I think that you would only have the 21-day limit would only be applicable if the refusal of leave covered a refusal of leave to the Privy Council.
Yes.
And even assuming that it doesn't, could you not claim the benefit of the time not having started to run in relation until the rules came into force?
That would be
in relation to the 42-day limit.
That is an additional ground on which the matter can be argued, my lord, because there is an extension of time granted by the transitional provisions.
Might I also point out, in addition to what the President said, refer you to Rule 5.3, 1 and 2, particularly 2 of the CCJ rules, which provides for, could you possibly make use of that?
The rule which gives a right to extend the time and not to prejudice a person by the expiry of a time limit if the party in default proves that his default was due to the existence of unforeseeable circumstances. And that provision is wide enough to deal with the extensions of time. But let me say that the new regime in most jurisdictions, where new rules are in place, allows the court, not as Acton said, to allow the rules to kill us from the grave, but rather allows the court to do real justice in case management and in dealing with matters before it. And that is another stronger ground for contending that the interpretation of rules such as this should not be restrictive in order to abrogate the rights of others. And when I look at the legislation as a whole, including the various amending acts, as well as the rules, it seems to me that no one is being driven from the court, access to this court, because of a restrictive construction of the relevant provisions. And it's for those reasons that we argue that the court has jurisdiction. But even if one took the alternative position to say that you had to read into Section 8 of the Act the great and general of public importance or otherwise, then it is my contention, it is our contention, that the matters before the court are matters of great general importance.
What matters of great general importance?
Let me deal with it, because
but I mean, whether the issue which is raised in this case is not whether the allegations are true or not.
No, but
Allegations against which are allegedly made against the respondents.
But that one has to look as whether the matter is one of public interest, of public importance. And there's a test for that, my lad.
I thought it was whether the question which was raised was one of general public importance.
Yes, my lord, but the questions are not raised. The questions are not raised in a narrow sense again, my lord. This is a case, the Court of Appeal, in its leave to appeal judgment, held that the matter was not of public importance because it was confined to an issue between a company which was alleging libel arising out of two songs. But that's a narrow approach to take. The issue is whether or not the applicant will have the right to justify its publication in circumstances where, first, the applicant is carrying out a public duty and has a right, what I describe as both a social and moral right to comment on public matters of public interest. And secondly, whether the matters being commented on are matters of public interest. And if I draw your lordship's attention to the skeleton argument at paragraphs 3.3, 3.4, the statement of claim, the respondents allege that the three songs of which they complain accuse them of inter alia putting on sale for human consumption many chickens which had been processed after dying from disease, and also pork from dead meat, pigs and stinking meat, giving instructions to pluck and process for human consumptions chickens that had died from disease, putting the public at risk by disregarding the public health, and carrying on a dirty business with chickens at the third respondent's farm, and carrying on the business in unsanitary conditions. In summary, the respondents themselves are alleging that the broadcasts were an attack upon them in respect of sanitary conditions of their business and property, a matter which involved the health, comfort, and welfare of the public of Barbados, to whom they sold their products by wholesale and retail, including fast food operator.
But none of this has been the subject of the debate in the courts below. What we are on about here, as I understand it, is whether the order of Mr. Justice Husbands was right in respect of striking out the defense.
Yes, my lord.
And in the circumstances that it was an application for general discovery, and that you had put in an affidavit which disclosed all the documents that you had. And I would have thought that the application for special leave to appeal was in that context. And therefore, if you had to demonstrate that there was a matter of great public importance, that it would have to do with the question which gave rise to the appeal, i.e., was this a proper matter for striking out the defense?
Yes, my lord. That is one of the aspects of the matter. But the effect of striking out of the defense is also to deny the applicant the opportunity to justify what was a matter of public interest, and that for the parties as a whole to have that determined, so that one could either look at the technical issue which arises by itself, or look at it in the context of what was being dealt with. And if you look at it in the context of what is dealt with, then I say that it was a wider issue. The effect of the judge's order was to deny the right to deal with that wider issue. I do so by relying on the case of Southampton, which is an interesting case, which is referred to at paragraph 3.6. This was a case, my lad, also of libel, as is shown at 3.7, at the suit of an incorporated trading company in respect of a libel calculated to injure its reputation in the way of its business.
Was there a trial in the South Hatton case?
There was a trial in the South Hatton case because it was trial in relation to whether it was a matter of public interest on which fair comment, a defense of fair comment, was necessary. But the Lord Justice Lopez, for instance, says, but is the matter commented on one of public interest? This is a question for the court. The attack upon the plaintiffs is in respect to the sanitary condition of their property, involving the health, comfort, and well-being of over 2,000 human beings. The sanitary condition of this large population is placed under the control of a public body who do not interpose. Can it be said that this alleged state of things is not a matter of grave public interest?
But what was the issue there? Was it the availability of a defense of fair comment?
There was the issue of the availability of the defense of fair comment. Yes, my lord.
It had nothing to do with the special leave to appeal or anything of that sort.
No, my lord. But your lordship is being asked to interpret the words when you're given special leave to appeal. What is the meaning of a matter of great general interest? And as was said, in this case, you may not find a particular case dealing with the matter. You have to look at it as a whole. Your honors are saying, inviting me to address you on whether it should be confined only to the unless order.
But, does that mean that, for instance, the readiness of the court to grant special leave should depend on the nature of the libel? So that if the libel was that some politician was alleged to be corrupt, that the court would be more ready to interfere and give special leave than if it were simply a libel which ruined some lesser mortal.
No, my lord, I would hope your lordships would make no exceptions for politicians. But take the case of Lance Armstrong in the Times newspaper. This was not a corrupt politician. This is an outstanding athlete. And the allegation against him was an allegation of doping. And the Times newspaper wanted to plead qualified privilege. And the court has held that in those circumstances, such a matter is that of the public in a modern, the interest of is that of the public in a modern democracy to free expression, and
Yes,
more particularly in the performance of their duty.
That is in the ballpark of the South Hatton case. That is whether the defense of fair comment is available.
Yes,
but
my
it
lord.
has nothing whatever to do with the granting of special leave.
My lord, I've never begun by saying that the case was won on the granting of special leave. The case, however, helps the court to determine what is meant by the public interest or of public importance.
Yes.
And that is where I've confined it to, my lord. And I said that when you're looking at the matter, you look at it not merely in the context, the narrow context of whether a technical rule has prevented someone from going
Look at the
forward.
question which arises on the appeal. You say that is too narrow an approach. But you see, because one view of the matter is that you focus on the question, the issue which is raised, or sought to be raised by the appeal.
Yes, my lord.
And you consider whether that question has that degree of public importance which would justify the grant of special leave. Now that is a totally different situation from one in which you are determining whether a defense of fair comment may be raised.
My lord.
Or so it seems to me, but...
No, my lord. Your lordships, let me say that one focuses, I agree with you that you would focus on the issue of the denial, the striking out provisions. And whether or not the right principles were applied in relation to the application for discovery and giving a further list of documents. And we have addressed that question. But I go further and say you do it in the context of what were the issues. The effect of the striking out order, in my humble submission, is to deny the applicant the right to a trial on the merits in order to raise and to set forth its view on a matter of public interest.
But whenever you strike out the defense and you give judgment to the plaintiff, that is denial of a trial.
Yes, ma'am.
And is there anything wrong about striking out the defense if it is proper?
There's no wrong in striking out a defense which is proper, if it is proper to strike out a defense. But likewise, if one has struck out a defense using the wrong principles, and it has an effect of denying the applicant a fair trial on the merits, those are considerations that the public are affected by.
So Henry, perhaps we could just get down to the nitty-gritty of the facts behind all this, because there seems to be a lack of clarity here. Is it your case that this striking out was a storm in a teacup on the basis that the plaintiff already had tapes of the relevant calypsos and the alleged libel, and therefore if, well, if it's true, I don't know, you'll need to tell me, if it's correct that your client did have those tapes, but only for 3 or 4 days or 3 or 4 weeks before they were deleted, your error was a venial sin of not accepting that at one time you had in your possession these particular tapes, although 5 or 6 years later, clearly you were right in saying you no longer had those. So a key issue, it seems to me, is are you correct in your allegations that the plaintiff did already have these copies? Because if the claimant already had them, then it's not significant. But it appears from me that the respondent claimants saying that they never had copies of these. Do we have any?
No, that issue is addressed. That issue is addressed in the skeleton arguments as well as in the grounds of appeal. It is not denied that the appellant, the respondents allege that they had a homemade copy of the tapes for which they were asking. That's not denied.
That is a challenge up to now.
That's unchallenged.
That is challenged up to now.
They have challenged it.
They have challenged it.
Well, my lad, if they have challenged it, we will have to go back to the disclosure documents. My lad, if I have had the plaintiff's disclosure documents to see what the plaintiff has in its list that it has disclosed. The plaintiff has disclosed in its list of documents the plaintiff's list was filed on the 15th of September 1993. And the plaintiff discloses defamatory material, a record of the Mad Chicken song, a record of Pluck It, a tape of Tit for Tat, and tape recordings from Voice of Barbados made of the songs played on the following dates, the 17th, 18th, 21st, 24th, 25th, 26th, 28th, and 31st of July, and the 16th of August, 1989.
Where those dates, any of those dates, the semi-finals and finals of the Calypso competition?
Yes, Malala.
Yes, sir. Well, we'd rather you keep it until later, but is it that you are going to concede something, or well, perhaps you could just state it briefly. What is your position?
Our position is set out in our submissions, and we are denying that he has homemade recordings or tapes.
Yes.
In respect to what the learned friends.
All right.
They are really mixing up another case respect to this. But I will deal with that.
Yes, very well. Thank you, Mr. Leonard.
I'm really taken by surprise because this argument was made in the court below, and this argument was made in the courts below, including before Mr. Justice Husbands, in full. It was made in the court below.
But you are referring to some document filed by the other side?
Yes.
The documents.
Wasn't it? You have the arguments before husband? You have the arguments.
Well, I think perhaps, Sir, you can proceed on the basis that they had in their possession what they disclosed in this document.
Yes, Miller.
And let us not get perhaps into what may be semantics.
Yes, Miller. Miller, in my submission on the issue of discovery, there are really two matters of great importance in which we contend that there were errors of law in the approach to the subject of discovery. We contend, and I'm going to be brief on it because it's all set out in my arguments, that the application was not an application under Order 24, Rule 7 for a specific class of documents. The application came under the inherent jurisdiction and did not specify any document that was required. Mr. Justice Husbands made no determination as to whether it was an application under Order 24, Rule 3 or under 24, Rule 7. The Court of Appeal said it was not an application under Order 24, Rule 7 for a specific class, but they will treat it as an application under 24, Rule 3. Now, if it was an application under 24, Rule 3, it is our contention that the correct principle to have applied was that prima facie the affidavit of Mr. Fernandez, the earlier affidavits of Mr. Fernandez were conclusive.
That's if it was an application for specific discovery.
No,
Or
for general discovery.
But the orders that were made, both after the first instance decision and but after both the initial order and the unless order, they were both orders which related to general discovery.
General discovery, Millard. General discovery. And Millard, our contention was that there was nothing in the documents that had been disclosed to say that there were other documents. And that in those circumstances, one could not go behind the conclusiveness of the affidavits.
At what point was it first alleged that these documents were, in fact, in the possession of the defendant?
They were alleged after the... Let me look at their schedule, Millard. I don't want to be wrong on this one. You have the list of documents.
In other words, when was the court's attention
drawn to the specific,
focused on these documents?
At the striking out provision, at the stage of the application before Mr. Justice Husbands, affidavits were filed by the respondents alleging that there were these documents. Affidavit was...
On what basis did the Chief Justice make his unless order? Was it not on the basis that of an allegation that there were there was incomplete disclosure.
For the Chief Justice to make such an order, to make the order, he has to make the order based on the fact that there is evidence in the affidavits of some nature.
I know that's what you say.
Yes.
He should have done.
Yes, Miller.
But I'm asking whether, in fact, at that point, that is, before he made the unless order,
Yes.
the allegation was put forward that the disclosure was incomplete because these documents had not been mentioned.
Yes. But from my memory of it, the affidavits were filed after the Chief Justice's order.
What's the position that there was a summons on the 12th of October 1994, and on the hearing of that summons, an order was first made by the Chief Justice, a simple discovery order.
That was a simple discovery order made for further and better lists.
Yes. And of course, your clients did not respond to that order, did they?
Yes, let me deal with the circumstances, but
Is it that
yes.
they didn't put in an affidavit?
And
They didn't put in a further and better list. Is that
the allegations were two, that there was no affidavit verifying the list. And there was an affidavit. So there was a sworn affidavit on the part of the respondents. That affidavit was perhaps I give the court the chronology of matters. We have got a chronology that is set out in the skeleton arguments below, Millard. The order of the Chief Justice, if I go back, Millard, the summons for directions was returnable on the 7th of July 1992. And the order was filed on the 23rd of May 1992. An order was made on that summons on the 7th of July 1992, giving 42 days for the parties to make mutual discovery. The plaintiff's list was filed on the 15th of September 1993. The notice of the plaintiff's applications for further directions was filed on the 16th of September 1993, and the plaintiff's summons for directions and for striking out was filed on the 16th of September 1993. And a series of affidavits were filed on the same day relating to the defendant's failure to file its list of documents. The defendant's list of documents, together with the affidavit of Mr. Fernandes verifying the list, was filed on the 23rd of November 1993. The plaintiff's summons for affidavit verifying the list and a further list was filed on the 12th of October 1994, and an affidavit in support of that. The affidavit of Mr. Fernandes had therefore been filed since the 23rd of November 1993. But as with leave, if I can make available the chronology, which was in before. The order of the Chief Justice, then the application before the Chief Justice to strike out the defense was filed on the 30th of December 1994, and the Chief Justice made an order on the 12th of December 1994 for the defendant to file a further and better list of documents.
But Sir Henry, before that order was made, in the submissions that were made before the Chief Justice, was specific mention made of these particular documents that were not disclosed?
Well, I haven't got the affidavit here, unfortunately.
In other words, did the Chief Justice make that order in contemplating that there were these particular documents that were not on the list, and a better list should be filed with these documents?
Well, there is no written decision of the Chief Justice on this matter, and no reasons given. And the order does not specify what documents were to be disclosed.
But was anyone present on behalf of the defendant?
No, and their reasons, that reason was explained as well, Millard. Unfortunately, most of the litigation in these actions is what I call satellite litigation, and most of it came at a time of inconvenience for the defendant. The defendant during those days, although it was still represented by Mr. David Simmons, as he then was, and he was in the process of making a change. My learned friend, Mr. Gollop, did not come into the matter until early January the next year, and I myself never entered into the matter until March the next year, when arrangements were made. And those were some of the matters that were urged on behalf of the applicant before the court below, so that the absence from the court, which is explained in the affidavit, was not because we were contumacious towards the court or ignoring the courts or the court's order. When
Anyway, we still haven't got an explanation of what triggered the subsequent orders for the further and better list.
What triggered the explanations for a further and better list? You filed it. Give me this. Well, the order was made by the Chief Justice on the 20th of February 1995, and if your lordships would bear with me, the unless order, a copy is being attached to the affidavit of Mr. Lashley. And the further list was filed on the 1st of March 1995. And that list repeated the matters that had been in the earlier list and added only 3 documents. And the documents added, 4 documents? The documents added were letters passed in between the attorneys and the registrar.
Dealing with adjournments, apparently.
Pardon?
Dealing with adjournments or something.
Yes, that was the position. And it also made a change, I think, to say that it did not have a tape of tit for tat, that there was a record for tit for tat.
No, but what we have been asking is what triggered the orders for further and better lists. What did the other side, the plaintiff, put before the judge?
They filed a summons. They filed a summons, Milan.
Yes, but the summons alone wouldn't have done it, would it?
They filed a summons and an affidavit by the first respondent.
What date was that?
That's filed on the 12th of October 1994.
1994. But the order of the unless order of the Chief Justice is on the 20th of February 95.
Yes.
And then you supplied it on the 1st of March 95. Well, what happened after that? After the 1st of March?
Well, after the 1st of March, the application was made to strike out.
Or an application to strike out?
To strike out.
Perhaps an inference can be drawn from the affidavit that was the basis for that application, the affidavit of Mrs. Asha Mirchandani.
Yes,
and there she refers to an exhibit, AM3, where there is a letter, I think, of 18th July 1991, from which it appears that David Simmons was instructed and wrote to advise that the song was included in the computer at station Yes FM 10.4, but on receipt of your letter and my advice it was forthwith excised. So that letter, I assume, must have been what prompted matters earlier. It seems to be evidence that there had been a tape recording of the calypsos at the time they were broadcast.
But I don't think he refers to a tape recording as such. There still is. We made disclosure in our list of documents of. Let me find that for you, Lordship. You have all list of documents. All list of documents. No, our list of documents. No, the actual list we filed. No, fine. But we had disclosed a record of the Mad Chicken, a record of Pluck It, and a tape for Tit for Tat. That was inadvertence, and it was changed to a record of Tit for Tat in the further and better list. Your Lordship asked why. There would have to be something, which is my contention, in the material before the learned judge, in our material, to suggest that there were other documents that had not been disclosed.
Well, Justice Hayton has suggested that it was that letter, that affidavit, exhibiting the letter from David Simmons, which provided evidence of a document that was not disclosed, but was in the possession of the defendant.
Well, let me reply to that in two ways. First, if there was a letter, it was a letter well before the disclosure stage took place, and therefore the counsel at the time had made disclosure of a record being played. If he was being contumacious, certainly he would not have made any disclosure at the time.
You see, that letter is not inconsistent with the disclosure that was made.
Not inconsistent at all.
Might I also point out to you, Sir Henry, that that letter dated the 18th of July, 1991, sent by Simmons. He said he was instructed to advise that the song was included in the computer of the station.
That's right.
But on receipt, it was forthwith excised.
Yes.
So I don't know how that isn't a tape. It's not a tape.
It is not a tape at all.
It's just in the computer.
That's right. And that by itself could not be evidence that we had additional documents. And that is why I said it's important to bear it in mind. In fact, I think it's important to bear it in mind that there was no specific document in the Chief Justice's order that we were asked to provide. And one of the things is that if an order for discovery and an unless order is being made in those circumstances, the class of documents and the particular documents must and should be specified. I don't think your honors will want to hear me on the clear law to that effect.
But there are two things. One is that an Order 24 Rule 3 order is about providing an affidavit of a list of documents. So it's a list you swear. You provide a list and you provide a verifying affidavit.
Yes.
Under 24/7, you provide an affidavit of documents. So those are the documents in your possession. But there's nothing about production of anything, is there? You don't have to.
No,
anything.
no, not at that stage.
Not at that stage.
Not at that stage. There's inspection that follows on the subsequent stage at which you would provide if you're asked to provide those.
What is the effect of that verifying the affidavit of documents and saying, well, these are the documents which I have. I don't have any other. Now, assuming that you had other documents, what is the result?
But that if the application, if you have made an affidavit, you have, in those circumstances, it's conclusive.
Yeah.
Unless you can find from the pleadings or from the documents themselves that there are other documents. And I've addressed that question in the paragraphs 4. In fact, the Barbados case, which deals with the matter adequately in a case of our Court of Appeal, is the case called Byron Tracy versus the Crane Estate Limited. And it's number...
But I don't think it's very helpful, really, for us to spend time
on the cases.
On the question of whether the order for discovery was rightly made or not. It was made, and it wasn't appealed from.
Yes,
the question is whether whether there was disobedience of it, and if so, whether that disobedience was contumacious.
And my submission is there can only be disobedience in the same. We filed a further list. What the court has found is that the 3 other documents filed were not enough to be a further list.
You see, the point is that assuming for the moment that you did, the defendant did have in its possession these tapes, but did not disclose them, even though they had been given 3 opportunities to do so, then I think you would be hard put to argue that there was a case for setting aside the order, striking out the defense.
Yes, my lord, but to get...
Regardless of whether or not the order for discovery should or should not have been made.
But to get to that stage, my lord, one must discount the fact that the affidavits were conclusive. The arguments that resulted on the affidavit, the later affidavits of Mr. Fernandes, resulted from the further affidavits of the defendants, making various allegations that there were additional documents. The affidavit of Mr. Fernandes reserved our position by arguing that we had said and verified by affidavit that there were no further documents, and that was conclusive. But out of an abundance of caution, and his affidavit was very clear, and without waiver of our rights, we answered the allegations. So that in those circumstances, we say that we should never have reached a stage where either the Court of Appeal or the judge of first instance get past the argument that there was a conclusive affidavit and that there was nothing in the documents themselves disclosed to show that there were a further list. And that the only way that you deal with that situation is if the other side can prove later in the trial, as has happened in cases, then you deal with the situation at that stage, but not by striking out.
I think comment has been made of the fact that you did not appeal from the order made by the Chief Justice. But it would be your case that there is no need to appeal because you had satisfied the order.
That was
I think the question then arises, what came up was when they applied to strike out to the defense. And that is when Justice Husbands made his order, isn't that it? And
yes,
that is what you appealed from.
That's what we appealed from, yes.
Could I just clarify what the disobedience was, and that you seem to have been saying that there was no disobedience because you did not have in your possession documents that needed to be disclosed. Was the alleged disobedience not having had documents in your possession and then which had been excised? You hadn't admitted that you had actually had these documents for 2 or 3 weeks, 2 or 3 months, and then they've been excised. Because that seems to have been what the Court of Appeal were mainly worried about. I'm
not sure the Court of Appeal was mainly worried about that. They made reference to that as saying that the letter written by Mr. Simmons is a letter showing how we conducted our affairs, and that's what they have referred to in their judgment, as I understand it.
But the unless order required you to disclose documents that you had in your possession, even though you no longer had them. So there were two aspects to it. It was old documents plus documents you still had.
Yes, but let's see what is the effect of that on the assumption that that is what the Court of Appeal is saying. The plaintiffs would have known up front of the letter of Mr. Simmons. It wasn't a deliberate suppression in those circumstances. It wasn't a deliberate suppression. So that in those circumstances, one of the things the court would have had to consider in applying a sanction or remedy was the issue of proportionality.
So you're admitting it may have been that you hadn't disclosed that you had these tapes and they'd subsequently been excised, but it was irrelevant because the plaintiffs already had copies themselves.
It was not a tape which was excised. It's something from a computer as referred to in the letter. But whatever was excised, I'm saying that disclosure was made in Mr. Simmons's letter of that. So that if there's an omission to put it in a list, then in my submission, that was de minimis. And it could not be
Mr. Fernandez, in
continued.
his affidavit, did he not concede that there was a time when they had the tapes, or may have had them anyway?
No, that one has to read Mr. Fernandez's affidavit with some care, because...
Well, I'm sure it was drafted with some care.
That's what the Court of Appeal said, Milan. That's what the Court of Appeal said, Milan. I think your lordships would know that if counsel is involved, there would be some care in drafting an affidavit of that nature. But that was not a ground for which to rule it out.
Well, what did Mr. Fernandez say about this?
But if I may be allowed to go to Mr. Fernandez's affidavit. Can you produce the list of documents? Mr. Fernandez, in paragraph 7. It's under number 8. Yeah. Tab 8. Have the other side got a copy of it? Yeah. Mr. Fernandez, in paragraph 5, for instance, Fernandez, if I may take you through, he explains why we were not present at the hearing before the Chief Justice. And he states, and this has not been contradicted, that he was compelled to relinquish the conduct. Mr. Simmons was compelled to relinquish the conduct of the action in January 1995. And then Mr. Gollop came into the action about the 23rd of January, and I entered into the action on the 23rd of March 1995. With respect to paragraph 2, that should be of the first plaintiff's first affidavit, I'm aware that she participated in a number of limited broadcast programs relating to businesses with which she has been associated, but he disputed whether she had any deep and reliable knowledge of the defendant's business or systems employed by the defendant. Then he states that the order in 7A made by the learned Chief Justice pursuant to the summons filed on the 12th of October and returnable on the 13th of October 19 1994, even though no certificate of urgency was obtained in connection with this summons, nor had the defendant waived the notice to which it was entitled. And the order was made in the absence of the defendant for the reasons set out in paragraph 2. At the time when the summons was issued, Mr. David Simmons had recently become Attorney General sometime in September 1994 and was in the process of making arrangements for the handing over of his then current work to other attorneys at law. We verily believe that as a result of a public office, he was unable to attend promptly to all matters of his former practice, and it took him some time to hand over papers in the action to Mr. Golla. He was informed by Mr. Simmons that no contumelious or intentional conduct was intended, and no such acts were being taken on his or the defendant's part to delay the action or prejudice the plaintiff's conduct. The failure to comply with the order of the Chief Justice as set out in paragraph 4 of the plaintiff's first affidavit was caused by the need to make on the process of making a change in attorneys at law, and necessitated by other matters hereinafter set out. Then, in 8.1, he merely recites the orders made by Mr. to file a list of documents. The list was filed. Both parties really were filing the list without any further order and outside of time. Likewise, the plaintiff's list makes the point in paragraph 8.2 was deficient in that the plaintiff itself had not given primary documents. And then he sets out the chronology. Paragraph 10 deals with the issue of non-compliance. With respect to the matters raised in the first plaintiff's first affidavit under the title Non-Compliance with Unless Order, I am informed and advised that the defendant complied with the order made on the 20th of February by filing a further and better list of documents and verifying the list on the 1st of March 1995. In the circumstances, the plaintiff's statements contained in paragraphs 7 to 26 of the first plaintiff's affidavit are objectionable in law and contentious and are admissible in that they seek to bring evidence by affidavit to show that the statements in the defendant's further and better list are untrue and to contradict the same. And further, upon their proper construction, the plaintiff's summons dated the 30th of December 1994 was not an application for a discovery of specific documents or a class of documents, and the order made thereunder was also not an order for discovery of specific documents or class of documents. With respect to paragraph 11, that the first plaintiff has placed her own interpretation on the order, and this is prejudicial. And I think Your Honor would have said that this next paragraph is carefully or cleverly drawn. But what it says is the statements which are disposed to by me in paragraphs 12.1 to 17 are being made without waiver of the defendant's strict rights, and the defendant will seek leave to rely on and use them only in the event that this court does not accept the contentions hereinafter advanced, since the defendant has been advised by its attorneys at law, and I verily believe that paragraphs 7 to 26 should be struck out for the reasons hereinbefore set out. So we took quite early the point that there was no material that entitled the court to go behind the affidavit and that the affidavits were conclusive. But we said, further, if you don't agree with us, then we have given an explanation without prejudice to our position. Now, the Court of Appeal, with respect, dealt with the explanation as given and the other affidavits contrary to the general principles of law that will apply in these cases.
You said that, first of all, this affidavit proceeds on the basis that the applications that had been made and the orders that were given were with respect to general discovery.
That's right.
But having seen Mrs. Mirchandani's affidavit, it appears as though now there was an attempt to interpret those orders as if they had been orders for specific discovery.
Yes, madam.
And this part of the affidavit is responding on that premise.
Yes.
even though you are not conceding that that is a correct premise.
Yes, Your Honor. And you will see it's similar to what happened in Lonro, except that the counsel in Lonro were obviously cleverer and smarter and more careful.
I doubt it.
In Lonro, they merely reaffirmed the position that they had no further documents. But here we are open with the court and not concealing or hiding from the court any of the matters. And we said we've done that without prejudice, but it's those very matters later that the Court of Appeal seeks to use against us, although we've advanced the argument to the Court of Appeal that of the conclusiveness of the affidavit, in order to say that there was material from which you could find that the lists were defective. Mr. Fernandez then speaks of the searches that he had undertaken, and he explained, in any event, and at all material times, paragraph 12.3, the defendant operated a system in relation to live broadcasts that if a tape had been made and used again, a portion of it would only have been used on the following morning, and then only part of such tape as would illustrate the crowd's reaction to the winning songs. Thereafter, the tapes, if any, of such live broadcasts would have been recycled either immediately or within less than a week, since the technical quality of such live broadcasts are not usually of the required professional standard maintained by the defendant on its stations. The defendant would, however, continue to broadcast the songs by playing the vinyl records of them, and the defendant has already disclosed these records in the list of documents. In the circumstances, and having regard to all the inquiries and searches made, I say and verily believe that the defendant has no live recording or tape or logotape of or relating to the events or of the songs referred to in the plaintiff's first affidavit. And I verily believe that the defendant has made full disclosure or has given explanations for the absence of such documents. With respect to paragraphs 13, 14, and 15 of the first plaintiff's affidavit, the defendant makes no admission concerning the verses as pleaded being different as alleged. Further, I have been advised by the defendant's attorneys at law that if the plaintiffs do have a record or tape concerning the said verses or any of them as pleaded, then the plaintiffs have suffered and will suffer no prejudice, since they will be fully able to produce the said record or tape. So that is the response to their, I haven't got her paragraphs 13, 14, and 15, but from my memory of it, there was evidence which said that they did have not a good version, but some version of these matters. And that's where paragraph 13 seeks to reply to that. With respect to see if you could find it for me. With respect to paragraphs 17, 16, 17, 18, and 21, for the reasons explained, I state and advise that I am the person who was responsible for programming of Yes FM. It was and is partially operated by a computer tape system. While correctly referred to as computer, since there are some computer features, the system is more of an automated system which facilitates continuous programming without the use of manpower and does not operate like a normal computer. For example, there are no saving devices and or printout facilities available. The computer stores no records. There are therefore no computer records which the defendant can produce. The computer is programmed to select tracks from various vinyl tapes for broadcast. A tape, therefore, is just a compilation of several records. These tapes are recycled on a regular basis. The computer operates from a number of tapes. These are in-house, which are made from vinyl records or compact discs. The computer has no memory or recording device to indicate which tracks were or are played at any given time. It is therefore impossible for the defendant to determine the frequency with which any track has been played from the computer. In 1989, the defendant did not have a log tape recording system for Yes FM. This has since been corrected from about the beginning of 1994. No logbook or register was kept or is kept in the library or anywhere else by the defendant. The only log kept by the defendant reveals the times at which there were segments of music, but not the actual names of the music played. A typical example is attached here to and shown in marked Exhibit VH1, so that exhibit was there to verify what he was saying. The only roster of announcers kept by the defendant shows the times the announcers were. At the material times complained of by the plaintiffs, announcers were required to select music on the basis of a particular type of mood, and he explains that they were not required to use playlists for music broadcasts.
Was there an issue on the pleadings or elsewhere as to what was played or when it was played?
Millard, yes, there was a non-admission. There was a non-admission of the publications. And to that extent, it wasn't denied, but it was not admitted. And to that extent,
there seems to have been some question of different versions of the song being sung at different times. Isn't that there was some special piquancy added for the competition?
No, as I understood the argument as it developed below, the piquancy was that when you are broadcasting live from the cultural event, there are comments that are made by people who are broadcasting. And that was the position, that the live broadcast from the festival was a little bit was different. And that's how I understand it was we do have, if the court wishes to see, a copy of Mrs. Mirchandani's the first affidavit to which she is replying.
Your contention is, Henry, is that the Court of Appeal did not place particular or give sufficient attention to the details of Mr. Fernandez's affidavit.
They seem to have given
no inferences from it, which you said would not be supported by the facts related in the affidavit. Is that your contention?
That has been my contention, and it is my contention that we really ought not to have reached the stage of having an affidavit to answer in circumstances where there was not a request for a specific class or an order for a specific class of documents. And even if there was, there were replies that it was difficult to consider that Mr. Fernandez was lying, as it seems to be the holding.
Was he cross-examined?
No, Millard. There was no cross-examination at all in this case. It was purely affidavits that were in.
But they said that it was unusual and stretching credibility to accept that they would not have had these broadcasts. Do you think that was a reasonable inference to draw in the circumstances?
I think, Your Honor, that it was an unreasonable inference to draw in the circumstances, and it really was not based on any evidence that was before the court.
The only evidence was his affidavit.
This is a speculation. To draw an inference by way of speculation that if you are a broadcast system, then you must have this, because it stretches my credibility to believe that you haven't got it. And that is really what that finding amounted to. It certainly wasn't a finding made by the judge below, because unfortunately the judge below made no findings other than that there was non-compliance. So that when one looked at it and one talks about concurrent findings and following the principle of the Privy Council, there really were no concurrent findings as such. Now, Your Honor, we must say that similar situations existed in the CBC case, and I've explained that in the arguments which are before Your Lordship, in which the allegation again was that CBC had a tape, and this was struck out. The defense was struck out. An application was made to restore.
Part of the defense was struck out.
Part of the defense was struck out. And an application was made to restore, and that application was granted. And the principle that seemed to evolve from that is clearly set out in my skeleton arguments. And in that case, she admitted that she had her own home recording of the broadcast as it was seen by viewers in the CBC matter. That's 7-2. And we argue that if the court had followed its own previous decisions in those circumstances, that it would not have visited, in this case, a remedy by way of striking out the whole of the defense. Because we say that the failure or neglect of one or inability of one party to discover relevant document does not prejudice a fair trial where a copy of the very same document is in the possession of the other party.
Well, we are not hearing the appeal.
I know, Millard.
Although we seem to have proceeded very much as though we were.
Yes, Your Honor, I understand why we did, because obvious.
What I would like, again, to you to address is, I would assume that for special leave, it is not sufficient to establish that you have an arguable case, or even that you have a good case. You need some other element.
Now,
I know that you say the other element is the public importance of this case. But I'm wondering if you would like, leaving that aside for the moment, to identify any other aspect of the matter which would justify our giving special leave.
Well, Millard, may I say, I know Your Honor has said that it's not necessary to show that you have an arguable case. Our contention is...
No, I said it's not sufficient.
Not sufficient.
Not necessary. I think it is necessary.
I think we have shown, with respect, that we do have an arguable case.
Assuming without
yes.
admitting.
Yes, that we do have an arguable case. Millard, the only other test here, if Your Lordships are going to revert to Section 7 of the Act, is whether the matter is one of general importance. Right,
You want to go over the same ground.
Right, so...
That is, to me, that seems to be a matter which is expressly referable to an application to the Court of Appeal.
Yes, Millard. Millard,
the other matter which I would take issue with you is you seem to treat this application as an application for leave to appeal against the refusal of leave, or as an appeal from that.
No, Millard.
I've never understood that an application for special leave to the highest court was an appeal from a refusal of leave by the court appealed from.
No, Millard. The reason why I have dealt with that is simply because the argument has been posited, and I'm sure will be posited here, that we have had 3 opportunities in order to convince the court otherwise. And the third opportunity would have been the leave application for special leave to go to the Privy Council. So I've answered that, Millard, by saying even in that application, the considerations that one would have wanted to be taken into account were not taken adequately into account. So I wasn't seeking as such to say that this is an appeal in the true sense of the word against the refusal, but to say that since there was an application to a third court, that we should not be foreclosed, because even that third court proceeded on wrong principles of law. And, Millard, I mean, when one looks to the third court, there was no analysis of even what were the concurrent findings of fact. No analysis at all.
I wonder now, with all due respect, looking at the judgment of the judge in the first instance, what took 8 days to argue? Because it's not reflected in the judgment.
But that I wondered what took 10 days to argue, but certainly we didn't argue for most of those 10 days.
But, you know, the judgment is rather terse.
The judgment of the Court of First Instance has really never analyzed any of the issues which arose before it. So that to say that there were concurrent findings of fact, one has to ask what findings of fact were there in the judgment of Mr. Justice Husbands.
Does he make an express finding of fact on anything?
On no issue whatsoever.
I don't think he dealt with the evidence at all.
Never dealt with the evidence at all. And that was after detailed submissions by my learned friend then Mr. P.D.H. Williams, which lasted several days over the period of time. And
I think he said on review of the authorities and the submission cited, he came to the conclusion that the defendant had not convinced the court of his failure. So one has to assume that he did review the submissions and the findings. Not to put his thought processes on paper, but
I think
doesn't help us much, does it?
It doesn't help the court. But for a court of appeal then to find that there were concurrent findings of fact, one has to ask what finding of fact there was, and what did he take into account.
Dropped in further.
So I remain at a loss, Millard, to urge any point to really to uphold Mr. Justice Husbands in any way, and our arguments is to the contrary. There were no concurrent facts. So to apply the rules that the Privy Council, as a matter of practice, where there are concurrent findings of fact, generally, not all the time, would not give further leave. In my view, the Court of Appeal was mistaken and approached the matter in the wrong manner. So that the Court of Appeal's judgment of August 2004, which is the one we were seeking all the time leave to appeal from, in my submission, should not be upheld.
So Henry, did you say that the protracted delays in this matter, both at the High Court and at the Court of Appeal level, operated to the detriment of the respondent?
Your Honor, let me say that.
Of the applicant,
Let me say that we were on the receiving end. It was a delay that affected both parties, but unfortunately we were at the receiving end of that delay. Of the 10 years mentioned in my...
Why do you say the receiving end?
We were the one who eventually the judgment came down against.
At least you had 10 years with the money in your pocket.
On the assumption that I had to pay money out of my pocket.
Of course.
Yes. but we
I think they were perhaps on balance would be the ones worst affected.
Well, Millett,
I don't think it's a question so much of that, because most of the delay, as you say, was judicial. Therefore, could not be attributed to either party.
Couldn't be.
It wasn't your fault or theirs.
No, Millett.
Some of it may have been, but not 7 or 8 years of it.
Millett, in this case, when you look back, really, it's more than 8 years in which the time was taken by the court to deal with various issues. There were occasions when obviously adjournments were asked for, but those do not amount to any significant factors. So that really, we say that we have good cause to complain of the delay as well. Now, the Court of Appeal, when we went for special leave, said it would deal with this issue later because the same issue was raised by the respondents. The respondents said that they hadn't had a fair trial, and that's shown in the decision of the Court of Appeal again, the decision is attached to the affidavits in 18 of 202 at paragraphs I think it's 28, isn't it? Is it 28? The delay issue. Before Mr. Moore. 28? Yeah. Well, that is at page 11, at paragraphs 24 and 4.
What is this? What is this?
The issue of delay.
What document are you referring to?
The judgment of the Court of Appeal.
Which one?
The second judgment on the special leave to appeal.
What leave to appeal?
It's paragraph 24, which deals with the issue. Alternatively, the appellant's notice of motion for leave to appeal be expedited, and consequential orders made for the following reasons. And this was the motion of the respondents in this case. The delay in obtaining the date for hearing the notice of motion prejudices the respondent's application for assessment and damages in March 2005, since sensitive dates have been fixed. The previous delay in the Court of Appeal, 2, Roman 2. This is a judgment, my lad. This is the
judgment?
page 11, paragraph 24, 2. Have you honor found it? Page 11, 11 at the top, para 24, ground 6, page 11, and Roman 2. The previous delay in the High Court for 3 years in giving its decision, thereby breaching the respondent's constitutional rights to a fair hearing within a reasonable time. The Court of Appeal has taken 4 years to give its decision in this matter, from the 17th of July 2000 to the 20th of August 2004, thereby breaching the respondent's constitutional right to a fair hearing within a reasonable time. And the courts find at 25, we make no comment on the question of delay at this stage. We return to it later in this decision. In the light of our finding on ground 4, we hold that this is not a proper case to be presented to Her Majesty in Council for decision. We therefore strike out the applicant's notice of motion. But nowhere did they come back to the issue of delay.
Did they paragraph 54? I think they did. Page 20.
Only in
23.
that's paragraph 54, yes. But only in a limited way. It is clear that the matter has been, but in our view, the constitutional right has not been breached.
Well, I think it would have been invidious for them to have commented on a delay of their own court, the Court of Appeal. Well, maybe from that standpoint.
So that the return, what I've said, there's been no analysis, I should put it better, there's been no analysis of the allegation made by the Court of Appeal at all, in any manner that is acceptable.
You say that we should take into account the delay which has occurred in determining whether to grant special leave or not.
Your Honor,
Wrong of us to do that?
Your Honor, in these circumstances, I do not think it would be wrong to grant. Both parties are complaining. Both parties are here complaining. And I think with justification, my lad, although I'm representing one party, with justification we are both complaining. And that is said in the affidavits as well. And I have to we complain more in the circumstances where we cannot get, which is admitted, a fair hearing, and in which we have been denied the opportunity of going on the merits of the case, for whatever hearing is available at this stage.
But I think, assuming that there is no distinction to be made between the contribution made by each side to the delay, then one would, in the normal course, be inclined to consider the plaintiff as having been worse affected, or would be worse affected by further delay than the defendant, simply because if the plaintiff succeeds, then it will have a financial consequence.
Yes, my lad, if the plaintiffs succeed, then the plaintiff's financial consequences can be met. Certainly, I mean, there are the issues of interest, there's issue of dealing with that. If the plaintiff fails, then obviously there's...
But this case, if you succeed both in getting leave and in your appeal, then the case is now ready to begin, more or less. Will it take another 15 years to come back to us?
Well, that I think the new rules are...
We're in the realm of Dickens, aren't we?
We are. Malad, the new rules are now coming into play. And hopefully I practice in the other jurisdictions of the Eastern Caribbean where the new rules are very effective. And most of this satellite litigation has disappeared. There is tremendous satellite litigation still under the old rules, which really is used by both parties in suits of this nature. And unfortunately, that causes a delay and is compounded. In this particular case, it's compounded by the judicial delay which occurred. But your Lordship asked whether it would take another 15 years. I don't think so in the context. I believe that with the changes that have taken place, particularly within the Caribbean now, in the Eastern Caribbean, that there's a greater sensitivity in case management. And certainly your Lordships, under your new rules, would have the power to make orders for speedy trials to take place. The only delay I can see occurring, my lad, is really for the court to set a date this year, if possible. But the parties can be bound to take steps and take those steps as promptly as possible that it will be necessary to move forward.
I would like to take you back, if I may, to the question of jurisdiction, because something which has an importance for us, which goes beyond this case, you will appreciate.
Yes, my lord. That's your honor.
But it is, of course, relevant to this case. I wondered, in your submission, how far back do the amendments go in terms of conferring a right of appeal on parties to judgments of the Court of Appeal that were given before the 8th of April in the case of Barbados? Is there any limit to how far it goes back? I mean, would it apply? Is there anything to stop it applying to cases in which there had been no application for leave to appeal to the Privy Council, and in which the time for doing so and already expired?
Well, I think one has to deal, therefore, with the provisions which we have already cited, which is the transitional provision rule, Rule 19, I think it is. Rule 19, which says in the case of appeals from judgments all delivered before the coming into force of these rules, the time for doing any act required by these rules shall not begin to run until the day after that on which these rules have come into force. That would be one consideration. The second consideration would seem to be the rules as they existed at the time whenever that judgment had been delivered, if it was delivered. So that there might have been, I haven't got the Privy Council rules in front of me, a cut-off point that would have occurred under the former rules before these rules came into effect. And then one would have to construe Rule 19 against the rule and alongside the rule dealing with the extension of time. Because there would have been a limitation of time under the old rules within which one can approach the court. But there are a category of cases, how many I don't know, that fall within this grey area of which your honours have spoken.
In the constitutional provisions amendments of the Barbados Act, was this taken into account, the cut-off date?
My lady, the construction, it hasn't come before any of the courts. But I can only say that the construction that has been put on them is that certainly that Rule 7 and 8 do not prevent persons from coming to this court within the provisions provided in Rule 19 and other times where there is no pending appeal before the Privy Council.
But can any argument be raised that quite apart from any transitional provisions in the amending acts, that under general principles of construction, the right of appeal to this court would only accrue in the case of judgments given after the 8th of, or after the 8th of April in Barbados, on the basis that legislation is not usually retrospective unless expressly
stated.
Yes.
Yes, ma'am. It would be those judgments between the, your Lordship said, your Honour said the 18th, I think it would be the 14th of April.
Wasn't it on the 8th of April that it came in?
Some came into effect on the 8th of April, but the combined effect of the acts, both of the Constitution Amendments Act and of these acts, is to have abolished appeals as from the 14th of April. That's been,
I think it's 8, but anyway.
The position, there's a practice direction issued by the Chief Justice, His Lordship Sir David Simmons,
I was about to refer you to that.
which speaks on the matter. I think it's paragraph 22. It's in our list of documents. You have the list of documents.
Yes, I have. It's all right. You can keep it.
Yes.
I think on the front page, the Learned Chief Justice in the practice direction number 1 of 205 states, the Caribbean Court of Justice Act as amended by the Caribbean Court of Justice Amendment Act 205 and the Constitution Amendment Act as amended by the Constitution Amendment Act 205-9 have the combined effect of abolishing appeals to the Privy Council from the Court of Appeal as from the 14th April 2005. In future, the Caribbean Court of Justice will be the final court of appeal. And
yes, but his practice direction deals only with the judgments delivered after the
14th of April. Yes. And this our judgment was delivered after the 14th of April.
Yes. But this is not the judgment from which you are appealing.
No, the second judgment, but the first judgment was the judgment under appeal.
Well, it was.
So that if it was under appeal, it would obviously be affected by these provisions.
It wasn't under appeal. It was the subject of an application for leave to appeal.
Yes, ma'am. So that my submission is that it was not a matter that was dead.
Well, you see, I am looking at it from a broader point of view, without reference to the facts of this particular case. And, well, I put the proposition to you and asked whether you think it is a tenable proposition. That is, just as, in fact, it be consistent with the Chief Justice's direction, that the cases that are affected are only those that are decided by the Court of Appeal on or after the 14th of April. In which case, that will leave you out in the cold.
Yes, sir.
Regrettably.
Yes. And that I've already argued that if one has to construe the statutes, taking into account all of the principles of construction, including not abridging the rights of persons, that would be a construction that I would argue should not apply in this case.
If our rules, the CCJ rules, give you 42 days from the date of a substantive judgment to lodge an application for special leave, then any judgment which was given 42 days back from April 14th is one which would have been capable of, a litigant would have been capable of applying to this court for special leave.
Yes.
So that it may, in fact, not necessarily be the date April 14th, but you may have to go back
42 days before. But then, one would have to take it that the legislature was penalizing and abridging the rights of a person whose application was already case before the court, determined by the court, and the litigant merely awaiting a decision of that court. That would be a construction that I would think would run counter to all of the constitutional provisions for access to the court and for fair trial.
But any provision in the rules like this, we have the right and the power under 5.3
to extend it.
time.
Yes, ma'am.
In exceptional circumstances.
Yes, ma'am. And that is why I argue that we have to construe all of them together against the basic rules of construction, and rather than.
See, I think that Rule 19 is based. It's on the premise that there is a right of appeal in the particular case in which it is invoked, a right of appeal to this court. I mean, it doesn't say so expressly.
In the case of appeals from judgments delivered before the coming into force of these rules,
in which there is a right of appeal
right,
to the Caribbean Court of Justice.
Because, Your Honor, of the 42-day period, it hasn't. There's no words within the section that places that limitation. expressly.
No. But,
So you would have to imply them,
well,
Your Honor.
you can see, I mean, we have to take the rules as written. And the travel preparatoire are not really relevant. But you can see that there would be a problem that had to be addressed in the case of judgments that were delivered after the 14th of April, but before these rules came into force.
Yes.
So I think that certainly one can infer that that was one situation, if not the only one, which this rule was intended to provide a solution to.
But why? In approaching the question of construction, Your Honor, why would Parliament wish to treat differently a series of matters that were before its court when it was seeking merely to replace a final right of appeal to one court to a final right of appeal to its own court, without expressly singling out, providing specifically for that sort of case? And where there's an alternative construction, using all of the rules not only that are implicit in the words themselves, but in approaching matters of constitutional provisions which affect the fair trials of persons, would be the preferable approach. But that I've never been fortunate to be a draftsman, although I did as Attorney General have from time to time to look at drafting statutes. But sometimes I think that maybe we have economized a bit too much on the use of words.
But anyway, we can console ourselves with the fact that we may have had an even more difficult problem if you had got leave. I'd end up here saying, well, I've got leave. And
But,
here we
Your
are.
Honor, had I got leave, I would have marched straight to this court. Your Honor, there's only one other matter addressed in here on the issue of bias. It was taken by my learned friend, Mr. Gollop, and if your lordships wish, he would, with your Honor's permission, I will ask him to address you on the matter.
Yes, briefly, I take it.
Yes, ma'am.
I'm grateful to your honors. On the 21st June 1995, Mr. Justice Chase, being then a judge of the High Court, dealt with the summons by the respondents to strike out the applicant's amended defense and made orders for the filing of further affidavits directed to the hearing of the summons. Yet the same judge, being then a justice of appeal, presided over the appeal, affirming the order striking out the amended defense, which is the subject matter of these proceedings. Your Honor, the philosophical underpinning of the law on bias is the requirement of impartiality. And Lord Hewart's aphorism, the stimulus, justice must not only be done, but manifestly and undoubtedly be seen to be done. Of course, Your Honor, that is taken from the Queen and the Sussex Justices ex parte McCarthy. And it is our submission that recent case law supports the view that a person exercising judicial function will be disqualified from acting unless the matter is waived where there is a real possibility of bias. And we refer to the maxim nemo iudex in causa sua. we want to emphasize the point that the rule against bias emphasizes the importance of appearances. And the point consistently made is that the appearance that an injustice may have been done is sufficient for a decision to be quashed if a judge is improperly acting as a judge in his own cause. My Lord, the authoritative statement of the law on the test for bias is cogently set out in the case of the Queen and Gough, 1993, to All England Reports 724 at 736. And we have a copy of that decision at tab 17 in the applicant's authorities. And the statement of Lord Gough, coincidentally, at page 736, states the following: "For the avoidance of doubt, I prefer to state the test in terms of real danger rather than real likelihood, to ensure that the court is thinking in terms of possibility rather than probability of bias. Accordingly, having ascertained the relevant circumstances, the court should ask itself whether, having regard to those circumstances, there was a real danger of bias on the part of the relevant member of the tribunal in question, in the same sense that he might unfairly regard or have unfairly regarded with favor or disfavor the case of a party to the issue under consideration before him." The test was more recently restated in the Queen and the Bow Street Metropolitan Magistrates ex parte Pinochet Ugarte, 1999, 1 All England 577, and that appears at tab 18, where the House of Lords ruled that Lord Hoffman's very tenuous association with Amnesty International was sufficient to support the view that there was a real danger of Lord Hoffman himself being affected by bias in the matter that had come before the court of which he was a member. Lord Hoffman was not a member of Amnesty International and had only served as a member of a charitable trust linked to Amnesty International. His wife, Lady Hoffman, worked with the Secretariat, but was not involved in any substantive decisions made by Amnesty International. But it is worthy of note that there is no requirement that there be evidence of actual bias. The test is one that is based on appearances. And Lord Gough at page 728 of the decision makes the point that bias is such an insidious thing that even though a person may in good faith believe that he was acting impartially, his mind may unconsciously be affected by it. So that, applying the test in Gough, the House of Lords held that Lord Hoffman was disqualified from hearing the matter, overturned its own decision, and ordered a rehearing before a differently constituted panel.
What was the reason for that? They thought that he might appear to be associated with one of the parties against...
He might have... Amnesty International was given some hearing, some audience in the matter.
Yes, but as regards Lord Hoffman, what was said is that there, as an apparent association with someone who had an interest in the case.
Well, there is further learning which I would come to later, which captures the point of a judge appearing in a matter before, even though he did not have an actual association with any organization or party to the action. And it is cited in the same.
What are the facts of this case? That the judge actually heard the matter, or
Our case, the instant case,
present case, yes.
the actual application to strike out
Yes.
first came before Mr. Justice Chase.
Yes. Did he enter upon the matter in any way?
He made orders.
To what effect? What are they?
The orders are set out in the documents. He made orders in respect of, if your Honorable Judge, pardon me, the list of documents filed below, proceedings in the court below, at tab 7, and he made the order. The plaintiffs, pardon?
He made orders for what? Filing of further documents, or did he make an order that affected the
It is ordered that the hearing of the summons be adjourned to the 12th and 15th, that any affidavit of the defendant in reply to the plaintiff's affidavit filed hearing on the 13th March 1995 be filed at least 7 days prior to any date here for the matter, and of course be the plaintiffs in any event certified for 2 attorneys at law.
That's the extent of the orders that he
That
made.
was the extent of the order.
But surely these were routine matters that a judge in chambers would make?
Yes,
That affect the substance of the.
yes, ma'am.
But would the making of that order have disqualified him from hearing the matter in first instance?
I would respectfully submit yes, my lord.
So every time you come before a judge in chambers,
Your
he
Honor,
makes
sorry,
an
sir.
order, that judge is disqualified
No,
from
sir.
sitting.
Indeed not, sir. Indeed not, sir.
To run out of
In that-
judges.
No, indeed not, sir. Indeed, Your Honor. I should respectfully like to refer your honors to the Queen and the Bow Street Magistrate,
Well, I think
ex parte
before you
Ugarte.
get there, perhaps
Yes,
you
sir.
might explain what precisely is there in these orders that would suggest that there might be a possibility of bias.
Not that order, per se, Your Honor. What could have happened later on when the case comes before the learned trial judge as president of the court? Certainly, he could not deny that he had knowledge of the whole case.
Might be an advantage. He read the papers.
Well, it might be a disadvantage too, Your Honor. Indeed, that is the learning of Lord Hope of Chivalry in the Pinochet case. And this is the point Lord Hope makes at page 593 of the judgment. As my noble and learned friend Lord Gough of Chivalry said in the Queen and Gough 1993 to All England 724 at 730, 1993 appeals cases 646 at 661. The nature of the interest is such that public confidence in the administration of justice requires that the judge must withdraw from the case, or if he fails to disclose his interest and sits in judgment upon it, the decision cannot stand. It is no answer for the judge to say that he is in fact impartial and that he will abide by his judicial oath. The purpose of the disqualification is to preserve the administration of justice from any suspicion of impartiality. The disqualification does not follow automatically, and that's the point, sir, in the strict sense of the word, because the parties of the suit may waive the objection, but no further investigation is necessary. And if the interest is not disclosed, the consequence is inevitable. In practice, the application of this rule is so well understood and so consistently observed
What
that
is the interest of Mr. Justice Chase?
the point is, the interest, my lord, is what may be construed as an apparent bias.
Well,
Sorry, sir.
That is merely repeating what I asked you. What was the interest? What was the specific interest similar to the interest of Lord.
The interest cannot be divorced from the appearance that if a judge heard a matter on the previous was well, he heard aspects of it. He heard certainly he heard the fundamental point which has brought us here today, the application. He knew of it before, the application to strike out the applicant's defense.
Wasn't he just fixing time limits that the affidavit should be filed on such and such a date? Wasn't that the extent of his involvement in the matter?
The application to strike out came before him.
Yeah.
And then it was adjourned, and he made certain orders, which we have just
The orders,
read.
orders of substance, weren't they that you should file your affidavits within a certain time? Wasn't it that? Procedural
Yes, ma'am.
matters?
But we are respectfully submitting that he could not avoid, in that situation, Mr. Justice Chase could not avoid the appearance that his mind could possibly have been biased in this situation, given the fact that he appeared before. But we are saying something more than that. We're saying, we are agreeing with Lord Hope of Chivalry that the situation did not require Mr. Justice Chase to withdraw. The situation required him to disclose that he was there before. Indeed.
Mr. Gollum,
Yes, sir.
I ask, were you present when Mr. Justice Chase made the order?
Yes, my lord. I was present.
Were you present when the appeal came before?
Yes, my lord.
Did you make any objection there?
No, my lord. But I would respectfully submit the responsibility is not mine. It is the responsibility of the trial judge. Indeed.
But
that was the
there
very
was
reason.
nothing for him to disclose that you were not already aware of.
But, Your Honor, it is very significant. It is very significant that the very reason that this matter had to be heard by a court constituted of 3 acting judges, the very reason this court had to be so constituted was the fact that every justice of appeal in Barbados at the time had some association with the case. Some had heard aspects of the case before, others were counsel. So that it is significant that in this very case,
Well, what is the significance of that?
the point is, the court itself was avoiding what might be appearances of bias. So it reconstituted.
When there was a real basis for that.
I would respectfully submit, Your Honor, that 1 or 2 of the judges were in no different position from Mr. Chase. They did not make any orders on it.
But Mr. Waller,
Yes, sir.
the submissions that you are advancing now, had the Court of Appeal taken a different view of the matter and had decided the application in favor of your side,
Yes, sir.
would the respondents have been entitled to make these very same submissions?
Would you raise that again, sir?
You are submitting that the judge, Justice Chase, should have disqualified himself.
Or have disclosed
Or
and
disclosed.
give
Fine.
the side.
Just no.
Yes, sir.
The submissions that you're advancing, wouldn't the other side have been entitled to make the very same submissions if instead of the Court of Appeal finding in their favor, they had found in yours?
Indeed.
So where is the bias? Where is the impartiality or appearance thereof?
The appearance is the fact that one side is able to say, I do not think that justice was seen to be done. There could have been a possibility.
But why doesn't he say that before the case starts? Why does he wait until the decision goes against him and then he cries foul?
Pinochet, Your Honor.
No. The difference between the 2 cases is that in Pinochet, Lord Hoffman had a duty to disclose something that was not or might not have been known to the parties. In this case, the fact that Mr. Justice Chase had dealt with the matter was well known to you.
My Lord,
you chose
Your Honor,
not to take
Your Honor,
any objection.
Your Honor, I must say that the matter only became known to us. We've forgotten all about it. The passage of time, sir. The passage of time.
Don't you think the judge might have to?
Well, but there is no my contention is there's no obligation on me. He has the obligation not to forget.
Yes.
I can forget.
Yes, okay.
Because so much time had passed. That's the obligation.
Yes.
But the point, sir, that the Court of Appeal ruled against that submission by citing a dictum.
Mr. Gollop,
Yes, sir.
we've gone past our lunch hour.
Sorry about that, sir.
Could you wind up?
Yes, sir, I'm winding up, sir.
Thank
Indeed,
you.
sir. They denied the application on that part of the submission by citing a dictum of Lord Justice Wolfe in the case of. Just give me 1 minute, sir. Okay. Yes, they cited Yes, sir. They cited the dictum of Lord Wolfe in the Queen and the Bristol Crown Court case, ex parte of Cooper and another. And that appears at page 22 of their decision, paragraph 50. It is quoted there at page 50 of the judgment. And they drew reliance on that fact where they suggest that, clearly, at page 884 of the judgment, clearly, however, there can be situations where after a period of time has elapsed, there can be no reasonable objection taken. There can be no reasonable objection taken to a justice who has adjudicated on a similar matter in earlier proceedings on an appeal in respect of a later decision, where the dividing line is to be drawn, will be very much a matter of fact and degree to be determined on the particular circumstances of the case. That was Lord Justice Goff as he then was. But Lord Justice Wolfe as he then was. But Lord Wolfe appears in the case Goff at 739. That's number 17 of the in the bundle. At page 739, Lord Wolfe, as he now is, makes the point at figure J, the last sentence, starting at the last sentence on the bottom of 739, figure J, it must be remembered that except in the rare case where actual bias is alleged, the court is not concerned to investigate whether or not bias has been established. Whether it is a judge, a member of the jury, justices or other clerk who's alleged to be biased, the courts do not regard it as being desirable or useful to inquire into the individual's state of mind. It is not desirable because of the confidential nature of the judicial decision-making process. It is not useful because the courts have long recognized that bias operates in such an insidious manner that the person alleged to be biased may be quite unconscious of it. It is because the court, in the majority of cases, do not require whether actual bias exists, that the maxim that justice must not only be done, but be seen to be done, applies. So that the whole point of appearances, we submit respectfully, is fundamental to the doctrine.
Yeah.
I'm obliged.
Thank you, Mr. Gordon.
I'm obliged.
Well, we'll take the break now, and we'll return at 2 p.m. We'll hear you then.
All right.